Y'all know when they sometimes say patience rules the day? Well, everybody was going off of that one motion that Steele filed, which was a doozy. But even the judge, she fired back 5 minutes ago. Man, let's do it. God, not again.
Exclusive, baby. Shout out to Thugger Daily, because he the one who put this out. So he goes, YSL update, Brian Steele is still not done. He files a supplemental motion to his motion to recuse Judge Glanville. Additionally, he argues that Judge Rachel Krause must also be recused because, among other reasons, Glanville donated $2,000 to her campaign during this trial. Check it out. So basically what it says is supplement to motion to recuse Judge Glanville comes now. Mr. Jeffrey Williams, by and through undersigned counsel, when hereby timely files this supplement, to motion to recuse Judge Glanville in the above referenced case. In support of this motion, Mr. Williams shows as follows. 1. This supplement to motion to recuse Judge Glanville, as well as the attached joint affidavit, Exhibit A, is timely filed upon Uniform Superior Court Rule 25.1, mandates that the time for filing a motion to recuse should not be later than 5 days after the affidavit first learned of the grounds. This motion applies to lawyers Love and Hilton, in addition to Judge Glanville, as all three are material witnesses in this case at bar, and all will be called by Mr. Williams during trial to show judicial and prosecutorial misconduct. See Reed v. State. This motion also timely moves to recuse the Honorable Judge Krause based upon the fact that she sits on the Fulton County Superior Court bench with Judge Glanville, and that in April 2024, Judge Glanville contributed $2,000 to the Honorable Judge Krause's re-election campaign. Also in April 2024, the Honorable Judge Krause donated $500 to Judge Glanville's re-election campaign. Mr. Williams' trial has been ongoing since January 4th, 2023, and therefore includes April 2024. Undersigned counsel derives no happiness when filing this supplemental motion. However, let justice be done through the heavens. What? Fall. Actually, heavens will not fall by unmasking biased and unethical members of the bar. Bruh, you talking heavy still. Man. And then it says, now that the transcript has been received by the defense, Steele's affidavit to recuse Glanville has fully been updated with all the relevant details. It says, joint affidavit of Brian Steele and Keith Adams, Esquire. We are over the age of 18 and suffer no legal disability. We make this joint affidavit based upon our own personal knowledge. We are counsel for Jeffrey Williams in the above style case. This joint affidavit is timely filed on Monday, July 8, 2024, which is 5 days from July 1st, 2024, to wit the date that offense first received the transcript of the ex parte communications that occurred in the chambers of Judge Glanville dated June 10, 2024. See Exhibit B transcript of the June 10, 2024 ex parte hearing, page 50 cents. Hence, this joint affidavit is timely filed. Offense hereby expressly adopt and embrace all statements made in the motion to disqualify, recuse Judge Glanville and the joint affidavit attached thereto dated June 17, 2024, herein, and rely on that timely filed and asserted motion to recuse, as well as the affidavit in to herein. Judge Glanville met with lawyer Love and Honorable Attorney Bumpus, lawyer Hilton, at times the court reporter, sworn witness Mr. Copeland, members of the District Attorney's Office, including but not limited to Fulton County District Attorney's Office, investigators Long and Hamilton, as well as members of the Fulton County Sheriff's Department outside of Mr. Williams and his counsel's presence, are discussed critical parts of Mr. Williams' case in violation of Mr. Williams' constitutional rights to a fair tribunal, right to be present, right to due process, right to a fair trial, right to assist counsel, and right to confront witnesses. See United States Constitution, Amendments 1, 5, 6, what the hell is XIV? I think that's like 14 or something like that. Whatever, as well as Georgia Constitution, Article 1, Section 1, paragraphs 7 and 14. The purpose of this ex parte meeting between lawyer Love, lawyer Hilton, and Judge Glanville was to act in unison in order to influence sworn witness Mr. Copeland to testify against Mr. Williams. There was absolutely no lawful purpose for this ex parte hearing to occur. To wit, there was no allegation by Mr. Copeland that he was somehow threatened. There was no allegation by Mr. Copeland that he was not satisfied with his counsel. There was no allegation by Mr. Copeland that he needed to meet with Judge Glanville. Now, I'm not going to read all of this stuff and everything because this is basically just kind of going in because it says Lawyer Love, again, misrepresents by claiming the Honorable Attorney Melnick has been talking to Brian Steele, Max Sharp. That is, he is not talking to us. They basically talking about the meeting and the part where it assumes, well, I don't even say it assumes. It make it seem like Melnick basically was working for Brian Steele and not protecting his lawyer. I mean, his client, pardon me. Steele had to turn around after he did some research and found out, yeah, this amended supplement to motion to recuse is filed to correct the former footnote 2 and a supplement to motion to recuse is the Honorable Judge Krause did not contribute $500 to Judge Glanville's reelection effort in April 2024 because it didn't make sense. He ran unopposed. So why the hell would you need to donate to his, like, it'd be stuff like this, bro, where I'd be like, man, we jumped the gun. But I do it too, so I can't even blame Steele.
Yeah, and so, I don't know, bro. It sounds like they might have pissed the judge off because she was basically like, nah.
Yo, Judge Rachel Krause has denied Thug's motion asking her to recuse herself from ruling on the recusal of Glanville. She rules that the fact that Glanville donated $2,000 to her a few months ago isn't enough to require her to recuse herself. Word. Check this out. In the Superior Court of Fulton County, state of Georgia, DeMonte Kendrick, Jeffrey Williams, Khalif Adams, Rodalius Ryan, Shannon Stillwell, Quamarvius Nichols, Marquavius Huey. Order denying motion to recusal, Judge Krause from hearing recusal motion. This case was randomly assigned to the court to consider certain motions to recuse Judge Glanville from further proceedings in this case. On July 8, 2024, defendant Jeffrey Williams filed a supplement to motion to recuse Judge Glanville. Through title supplement, a portion of this filing seeks to recuse this court from hearing the recusal motion. This court, therefore, must consider the portion of the supplement seeking this court's recusal before proceeding further. Pardon me. It says USCR 25-3, and I freaking knew it. I knew I should have read the whole damn thing. It says this, and this where I'll be so pissed off with some of these freaking lawyers. It says when a judge assigned to a case is present with a recusal motion and a company affidavit, the judge shall temporarily cease to act upon the merits of this matter and determine immediately whether the motion is timely, whether the affidavit is legally sufficient, and whether the affidavit sets forth facts that, if proved, would warrant the assigned judge recusal from the case. If all three criteria are met, another judge shall be assigned to hear the motion to recuse. Wow. Monday versus Magnolia Advanced Materials Inc., 303 Georgia, 764 internal quotations and citations omitted. We just finna read exactly what happened. Defendant Williams' motion in footnote 2 and later a lengthy paragraph 52 asserts two bases for recusal of this court. Defendant Williams asserts that recusal is merited because of a $2,000 donation made by Judge Glanville to this court's recent reelection campaign. Defendant Williams also asserts that recusal is required because it is inappropriate for any judge to preside in any election where one of the parties holds a judicial office in any other court which sits in the same circuit. Defendant Williams' supplement seeking to recuse this court is supported by an affidavit, albeit only footnote 1 and paragraph 63 as to this court, and it was filed within 5 days of this court being assigned to handle this case. Therefore, the first two criteria are satisfied, and the only consideration for the court is whether Judge Glanville's campaign donation to the court's re-election campaign warrants recusal. The Georgia Supreme Court has held that the mere fact of a campaign contribution to a judge, even from a party to the case, does not warrant recusal where the contribution was not exceptionally large. Yeah, that's the Supreme Court. This just sound dirty as hell, bro. This just sound like, if I'll get more into it why it sound dirty as hell, even though technically it's all right. Affirming denial of recusal motion based in part on a campaign contribution from one of the judge's colleagues on the court who had recused from the case. Allegations of unexceptional campaign contributions or commonplace support during a judge's election campaign ordinarily are insufficient to require referring a recusal motion for reassignment to another judge. The Code of Judicial Conduct reiterates this point, noting that when a campaign contribution is less than the maximum allowable contribution permitted by law, an affidavit seeking recusal must allege additional facts demonstrating the need for recusal. CGA RCJC Rule 2.11 Commentary and Summary Rule 2.11 provides that if contributions made to a judicial candidate or to the candidate's campaign committee are permitted by law and do not exceed the maximum allowable contribution, then there is no mandatory requirement that the judge recuse, because under Georgia law, the asserted campaign contribution would not warrant recusal, and defendant Kendrick has not alleged any additional facts demonstrating the need for recusal. He has not met the third criteria for recusal. Defendant Williams' additional assertion of judicial qualification Commission Opinion 220 in support of this motion is unavailing for two important reasons. First, Judge Glanville is neither a party nor counsel in this criminal prosecution, nor is this mandamus action, and defendant Williams cannot make it so by filing a recusal motion. So Opinion 220's conclusion that a judge should not preside in an action when one of the parties holds a judicial office in the same circuit does not apply to this circumstance. Second, and perhaps most importantly, defendant Williams' motion ignores the clear directive of Uniform Superior Court Rule 25.4. That rule directs that in a multi-judge circuit like the Atlanta Judicial Circuit, a recusal motion shall be assigned for hearing to another judge, and the selection shall be made by use of the circuit's existing random and partial case assignment method. This court does not relish the task to which it has been assigned, but it as much as the duty of a judge not to grant the motion to recuse when the motion is legally insufficient, as it is to recuse when the motion is meritorious. For the foregoing reasons, the portion of defendant Williams' supplement and amended supplement seeking to recuse this court is hereby denied. It is so ordered this 9th day of July, 2024.
So Krause ain't going nowhere, and I ain't gonna hold you, bruh. Still, A+. I'm gonna get still an A+. Because at first, I'm like, still can't be that damn dumb, bruh. You had to have read 25 of that rule 25.1. You had to have read it. So I think this is just me being with my sinister self. Sometimes y'all like it, sometimes y'all don't. In the last couple weeks, y'all didn't like it. For the past year, y'all liked it. I think still new, bruh. Hey, yeah, Judge, we gonna go ahead and put that little business out. I'm going to put it out wrong, come back, clear it up, and then turn around, not read all the rules. Because Steele did this before with the older white dude when they were trying to get bonds. And I can show y'all where Steele didn't tell the whole entire truth of something that had happened. And then it was like, yeah, it's true, but not the whole entire truth. right? So here's what I think Steele did. And it's freaking genius. I think Steele already knew that Krause was not going to sit up here and get recused. I think he knew it. I think what he said was, I'm going to make it look like you dirty as hell. So now when your ruling goes about mentally, you might say Glanville did nothing wrong. You might. But also at the same time, you had to weigh on how it looks. See, Weinstein said something that was very prominent. He said there's a cloud hanging over the head of this court. And he asked the judge, don't you want to do this because of the cloud? And the judge was like, nah, because the judge knew, hey, bro, you're filing this motion wrong, and the Supreme Court said as much. But the judge did it reluctantly. So I ain't going to hold you, even though they didn't get what they wanted, because you can't take it to the Supreme Court. The Supreme Court had already ruled. And yeah, Weinstein might go and do an interview like this is wrong and all that crap and everything like that. And y'all can't say, oh man, we're going to take it here and take it there. Now, here's one thing that I know I'm not smarter than Steele. I'm not smarter than anybody. I know Steele got to be looking at those contributing donors and has to look at that and say, all right, how many of y'all is cool with Krause? Because if you give just a little bit, and somebody else gives just a little bit and just a little bit, it all equals the same. It's like, hey, I could throw $2,000. He could throw $2,000. She can throw $2,000. He could throw $2,000, and they could throw $2,000, and that makes $10,000 right there. Instead of Krause just going ahead and giving, instead of Glanville just going ahead and giving $10,000 to Krause, because I ain't gonna hold you, it didn't make sense for her to donate to Glanville. He ran unopposed. What are we giving money for? Ain't nobody running against him. It's not like the presidency where you already elected and you going through and you got to win your primaries and all that. If you're already president and then you come through and then you fight the Republican side or the Democratic side, no. So A+ to Brian Steele, because you did a mental tactic. I don't believe Brian Steele was that damn dumb to sit up there and do that. So, you know what sucks too? Miss Love gets an apology because she did nothing wrong, bro. She actually does have a family member that's very close that absolutely is basically sick. If it's true, there's an apology for you. My bad, shawty. Or that Judge Krause. Whoo. She Billy Badass out here. And she just saved Glanville, Hilton, and Love. But it doesn't factor to me that you wouldn't read more of those lines. I was actually going to do that Saturday. I was actually going to do it tomorrow if none of this crap would have came out. And I would have looked at, well, what is 25.1? And then what are the motions underneath that? Because y'all seen when I read the ex parte stuff. And everybody keeps pointing to that email and saying, oh, well, Woody didn't feel this, Woody didn't feel that, and all that crap and everything. And he never said this, he never said that. Like I said, Love was the puppet master because you don't get any emotions out of those emails unless you write in caps lock. So I think she manipulated the situation. I'm not believing that Glanville was all the way on it like that. I think Glanville got manipulated by Love, and that's why we're sitting here today. And like I said, if it's staying in Fulton County, bruh, that judge ain't going nowhere. But, hell, he might. Krause might just, boom. But then again, no other judge wants to take this damn case. So, I think Steele knows that. And basically, another judge is going to, if it proceeds forward, you got to dismiss the case. Prosecutory misconduct on behalf of the judge and the lawyers, Doug would be going home. Or they would just disqualify the DAs, obviously they would have already disqualified the judge from hearing it, and then they would have to put in new DAs, and then you'd have to, they had to be counted to speed. And if it's Brown and the white dude and all that versus everybody else, I like YSL. It's slatty out here. But other than that, bruh, wow. And some of y'all mad because I didn't put the video out, bruh. Some told me. I'm 50-50 on this. It's a flip of the coin. Some said, just hold off, bruh. Don't put your video out just yet. And that's why I didn't. Because I thought in my mind, something else is going to happen today. And you lo and behold, I would have been putting out 2 videos today. I don't want to do that shit. I got stuff to do. But subscribe, turn the bell, stay notified, share to keep your people aware. The only channel to come to when it comes to that breaking YSL news. I'll catch y'all tomorrow.